So, ladies and gentlemen, all protocols observed. Good morning, good afternoon, and good evening from wherever you are joining us from. I'm excited to be talking to you today and to discuss the role of technology in supporting access to justice, aptly themed justice in the digital age. I'll particularly be talking to you about cashless payments. And by way of introduction, my name is Waithaka, and I'm the head of legal and secretarial services at Safaricom PLC, which is an integrated communications provider based in Nairobi, Kenya, providing both telecommunication services on the GSM platform and mobile services in the form of the world-renowned M-Pesa. And I'll kick off by describing how mobile payments aid ordinary citizens to access justice. So access to justice is a fundamental ingredient of the rule of law. And from an administrative point of view, it invokes a person's right to access the courts so that the law can enforce their rights. And as you may be aware, Article 48 of the Constitution of Kenya echoes this expectation as a fundamental right and requires the state to ensure access to justice, and in so doing to ensure that any fees that may be payable to facilitate such access do not act as a barrier. Mobile payments can aid this access in that mobile money channels allow mwananchi or the citizen to pay for fines, court fees, and other administrative payments, all from the convenience of their phone and without the physical intervention of friends and family. And in the case of Kenya, this integration of mobile payments to facilitate payment of fines was introduced in 2012 by what the judiciary dubbed as Lipa Faini Chap Chap. Chap Chap in Kenya means fast, denoting the speed factor introduced through mobile payments. So easing payments is empowering because mwananchi can now make payment for a required process without the fear that they may perhaps lose their job because they have to leave their office to go to a bank, for example, to make the payment or to buy a banker's check. I would, however, like us to look at justice and its access more broadly to encompass a person's right to not only access justice through the legal system, but to access government services. This is a right that Kenyans often precede with a chant of haki yetu, meaning my right. Accessing government services, be they health, education, immigration, birth, registration of deaths, or even marriages. And as many of us may have interacted with what we call Sharia House in Kenya, for the registration of a company. All of these are, in my opinion, a facet of an individual's right to justice. Mobile money channels have given greater access to these services, again, by facilitating convenience. Safaricom's network now reaches 95% of Kenya's population, while M-Pesa, which is our mobile money solution, has over 215 agents and an ever-growing list of integrated partners, including banks, circles, merchants, etc. All of these have provided reach and convenience to Safaricom's over 30 million customers, and through their ability of interoperability, have given access to other customers on other operator networks to be able to access our various channels and for our customers to send money to customers on other networks. This capability, coupled with the government's efforts towards enabling e-justice and e-government services, has meant that a greater proportion of Kenya's population is now able to conveniently access, pay for, and receive government services, which has in turn allowed government, including the judiciary, to improve on their service delivery and discharge their obligation to mwananchi. In addition, I would like to say that mobile money channels have contributed to an increase in revenue collection, which in turn increases the coffers available to deliver services to mwananchi. So what role can we as lawyers, policymakers, and indeed all of those who are participating in this webinar do towards playing our role in accelerating cashless payments and supporting our digital economy? As policymakers, my urge is that we should ensure that enabling regulation exists that steps up and motivates the growth of cashless payments. And as lawyers, we do have a role supporting and leading this charge. As far as our regulatory perspective is concerned, I would like to call out the support that Safaricom has received from the central bank in terms of the CBK directive to increase the size of the mobile money wallet from Kenya shillings 150,000 to 300,000 in terms of daily transaction limits, which has greatly supported businesses in particular. The recent appointment of a data commissioner is also a significant step towards applying the provisions of the Data Protection Act, which is indeed a strong enabler in a world where customer information is shared in seconds. As Safaricom, we believe in the protection of customer data, and we are amongst the first companies in the region to have a data protection office mandated with overseeing the protection of our customer data. We believe that such steps, not only from Safaricom, but from other organizations, will play a leading role in giving a stronger impetus to and confidence in our economy. Sandboxing also needs to be embraced through regulatory and policy action as a step to testing the application of technology to various activities. We have seen the CMA, for example, which is the Capital Markets Authority, take a lead in this area, and it is our hope that other sectors will embrace the same to ensure that we continue to embrace, lead, and motivate greater innovation, not only in the cashless payments sector, but across the entire technological spectrum. It is this support that fuels innovation, which in turn will contribute to the continued development of not only this country, but our continent. When regulation becomes aggressive, then it is the customer that suffers, since the customer ends up with restricted options and choices. So, as we engage on the issue of payments, I think it's time now to internalize and look ourselves at as lawyers and the aspect around cryptocurrencies and whether these can indeed be acceptable forms of payment. And I'll localize this to the Kenyan context because this is the economy that I have a better understanding of. Kenyans have also been at the forefront, at least from this region of the world, as in regards to adoption of cryptocurrencies. In fact, I read a newspaper report that Kenya holds over 100 billion shillings in cryptocurrency. However, the question to be asked is, does this adoption mean that lawyers will accept cryptocurrencies in payment? I think there are various ethical issues that persist and that may prevent the immediate and widespread acceptance of cryptocurrency as a payment method. And in the case of the central bank, it has come out to warn Kenyans that cryptocurrencies are not legal tender in Kenya. And although the CBK did not declare cryptocurrencies to be legal, it did not legitimize its use either. This then creates a dilemma. If the cryptocurrency is not legal tender, then what is it? Is it an asset that can be bartered, as has been so categorized in economies such as Australia? Or is it an asset that a lawyer can accept? If that is the case, then we would have a situation where the lawyer would fall foul of the LSK Code of Standards of Professional Practice and Ethics, which prevents a lawyer from accepting a transfer of property from a client in settlement of fees. And this prohibition is in place because it then converts the relationship between a client and the counsel into one of transferor and transferee, which then becomes more akin to a business relationship, which can then lead to incidences of a conflict of interest. Furthermore, cryptocurrency is not recognized as a legal tender, as previously noted. Then if that is the case, then how will the advocate discharge his responsibilities, for example, in maintaining a trust account? If he was to receive cryptocurrencies to hold, for example, in escrow for his client, the advocate, appreciating the restrictions that are in place as guided by the central bank, would not be able to recognize this in his accounting, which is a regulatory requirement for all advocates in this country. I must also call out the fact that advocates are under responsibility to know their customers, and they're not, should just always ensure that they are not used to cover up illegal activity. Cryptocurrencies provide a high level of anonymity. This doesn't mean that everyone who holds cryptocurrency is a criminal, but it does mean that that the advocate may have greater difficulty in identifying the source of these funds, which then means that the lawyer will not be able to discharge his obligations in terms of applicable practice standards. Therefore, from this discussion, I can say that there are several ethical issues that need to be addressed, and these issues may delay the acceptance of the currency. I did not say stop, I just said delay. And so the call to all of us is then to engage in further discourse around this issue to determine whether there are mitigations that can be put in place to facilitate and to allow for the acceptance of cryptocurrency, or to further engage with regulators across the various financial services sectors to identify the concerns and to determine if there are other mitigations that have been put in place so that digital currencies and all their forms can continue to evolve how we do business. So as we continue with our discussion, we have spoken about how mobile money has enhanced access to justice through payment of court fines. Again, I rehash the aspect of gaining justice in terms of accessing services from various government departments. And as we have seen, this digitization of our economy, integration with mobile money, enhances the growth of our economies and an evolution in our societies. So in Africa, it's important that we then take our own path and ensure that regulation does not serve for growth. Because if we do take a path of aggressive policy intervention, then this will result in a situation where a less regulated global player will expand into our space and make the rules. So M-Pesa has thrived despite the presence of the likes of Ant, Visa, MasterCard, etc. But the question is, will it thrive into the future, or shall it be stifled at the hands of regulation? I hope that the deliberations over the next few days will tackle some of these questions, and participants will carry with them new information and knowledge that will help them shape the respective domains and help anchor Africa as a home of innovation, will help drive Africa as an enabler of access to justice and growth of business through intervention and embedding of technology, including digital payments in all its forms. Thank you.